And welcome back to the Law News Network. I'm your host, Amy Dash. I'm joined by Ken Belkin, a criminal defense attorney here in New York. Let me just explain that we are not allowed to show this very disturbing video of Adrian Loya basically strapped a GoPro to his stomach while he was committing this murder and filmed the entire thing. Ken, this video, it's about 50 minutes long. The judge decided to show a small portion because he said it just might be too emotionally disturbing for the jury to handle. What do you make of the fact that he filmed the whole thing? What does that say about his mental state at the time of the murder?
I mean, look, obviously this guy is insane. Is he legally insane? Probably not. He probably knew what he was doing was wrong, which, does not make for an affirmative defense of insanity. Interestingly, I believe the judge is going to allow the jury to see the whole video. I think in the interest of judicial economy, he didn't want to play the whole video in open court, but the defense really wanted this 15-minute snippet of Mr. Loya talking to himself.
Not only did he film the entire gruesome scene, but he had a soundtrack for the murder. He literally put together a string of songs ranging from heavy metal while he's pumping bullets into this Lisa Trebnikova, who's a Coast Guard, into her body. And then it transitions into a symphony, a string quartet while she's laying there lifeless. What do you make of that in terms of planning? Because that is an element of deciding whether he was legally insane or not.
Well, I mean, look, everyone likes playlists when they engage in activities. Not to make light of this, that's horrible. But look, it does show an element of planning, of deliberation. I don't know that it really would speak to the issue of his sanity and whether he knew the difference between right or wrong. Someone can be insane and still make a playlist. I do think a lot of planning went into this. His 250-page manuscript. He staged the scene with incendiary devices, set his car on fire as a roadblock, hid a gun, as you informed me, during the break under a neighbor's deck. He went to the extreme in planning.
And for months on end.
For months, over a year.
To the point where he did reconnaissance missions, rehearsing what was going to go down.
Yeah, he didn't want to go into it without rehearsing, of course, It's bizarre. This man is sick, but I don't know that he's legally insane. I haven't seen anything. The defense had a pretty good day yesterday where they played that 15-minute clip where he's talking to himself and having a panic attack, and that makes him sound pretty crazy. And then they had, the prosecution had their expert, Dr. Martin Kelly, take the stand, who his medical opinion was that he due to his mental health issues, Asperger's, or on the autism spectrum, he couldn't appreciate the difference between right and wrong.
But the fact that Dr. Martin Kelly diagnosed him as having Asperger's and then admitted that he didn't even use the diagnostic manual because he felt that it was a slavish cookbook. Yeah. Does that make him credible if he's doing a subjective assessment like that and admitting that he only uses the codes to bill the insurance company?
Well, look, he's going to have to, the jury's going to have to weigh what he said, his testimony, whether he's credible or not. Certainly the man is credentialed, decades of experience in the field, currently teaching at Harvard Medical School, graduate degrees from Tufts. He knows his psychiatry. No one can say he doesn't. Look, medical experts can look at the same set of facts and draw radically different conclusions. It happens all the time.
And we saw that today with Dr. Judith Edersheim, where she said that there's no way that he has Asperger's in her opinion, or even any type of autistic spectrum disorder, because she said things like, listen, this guy can understand sarcasm. He can understand subtle humor. He can give people the silent treatment. He can read facial expressions. He can put things into context. He has friends. He has relationships. He enjoys a range of different activities. So she felt that he really had a personality disorder rather than an autistic or Asperger's disorder.
Well, see, that can cut both ways, because if it is in fact a personality disorder, that personality disorder may have a bigger impact on his ability to appreciate the difference between right and wrong. So it can cut both ways, and the defense can spin it.
Would it get into the way of him being able to conform his behavior to the law, which is also a test for legal sanity?
Look, I think the real issue is the real mental health diseases here that would affect his ability to appreciate right and wrong and to conform his behavior to the color of law, as you just noted. those are the more serious mental illnesses like schizophrenia, bipolar, these illnesses where you're hallucinating, you're having paranoid delusions. That doesn't seem to be the case here. He, had a motive, as bizarre a motive as it may be. He still had a motive and a reason for doing the things he did, and he planned for law enforcement to respond. People don't plan for a response from law enforcement if they don't have an idea that what they're doing is wrong.
And Dr. Judith Edersheim also commented on the fact that his motive shows that he's sane by the mere fact that it was grounded in reality. He had a reason. He hated Lisa Trepnikova because he felt that he was rejected in a sense. After he accused her of sexually assaulting him, she kind of distanced herself from him, and he felt that she didn't want to be in his life anymore. And undoubtedly, the guy was obsessed with her. Was that not the case?
Yeah, that's what it looks like from the facts. Just the sheer fact that this guy can write a 250-page manuscript about this and her, that's a little bit obsessive. But obsessive doesn't mean that you do not understand the difference between right and wrong.
What about the fact that he's standing at attention like a soldier in this courtroom and exhibiting behavior that's bizarre in front of the jurors? Will that impact them?
Look, I think at the end of the day, these jurors, first of all, the insanity defense, when it's deployed, most times is not effective. For whatever reason, even in cases where it should be effective, jurors don't typically believe it.
Let me tell you why.
You tell me why.
Let me tell you why. No need to interrupt. No, I don't mean to interrupt you here, but this is why. Because if you're insane, you're not legally responsible, right?
And people want people to be
responsible. And then what happens? You walk out on the street and nothing happens. You can literally murder somebody, be crazy, and you're released into society.
Well, also I think
he'll be evaluated, right?
Oh yeah, well he had to be evaluated. I think there was an issue. They said he might have lacked competency to stand trial. So there's always evaluations, especially when it comes to the insanity defense. But look, I think this guy, he's not hallucinating. He was a member of the Coast Guard, formal education, and
he's functioning in the Coast Guard while he's planning the murder.
And by the way, Dr. Martin Kelly made a point of saying over and over again, this individual is high functioning. High functioning individuals presumably can tell the difference between right and wrong and conform their actions to the color of the law.
Right, that's exactly what you said. And now the burden here is on the prosecution. So that means this. If the jurors find any type of doubt, any reasonable doubt whatsoever, they have to acquit him. But then when they acquit him, Ken, he's going to be evaluated by a judge, and the judge is going to say, in order to decide whether to put him away for 6 months, the judge has to find that he's crazy beyond a reasonable doubt. What does that mean? That it's easier to get away with murder, basically, than to be committed to an institution after you kill somebody.
Look, and also, look, I think another reason why these juries don't believe the insanity defense is, look, number one, it's very tough. As a normal, sane, rational person, it is very tough to step into the shoes of someone who suffers from a mental illness like schizophrenia. It's hard to imagine. You can't relate to it. And if you can't relate to it, your verdict it's going to be a reflection of that.
And there's no logical pattern of behavior.
No logical pattern of behavior. It's insane. But the other thing is, I think there's this mood, it's in the zeitgeist in our society, that, these defense attorneys, they're trying to pull the wool over your eyes as a juror with this insanity defense, that it's all a bunch of BS. And there are these cases, there are these extreme cases, like the temporary insanity defense. The Twinkie case? The guy said the Twinkies made him temporarily insane out in San Francisco a few decades ago. They teach this case in law school because it's just so insane. And the guy was acquitted. And I think people are like, well, I'm not going to be a juror that acquits someone of murder for insanity.
Well, because the problem, like I said, is that there's just no consequence. And then even to be committed for a mere 6 months after you kill somebody, because there's no doubt that he killed them, Lisa,
no
because he filmed it.
Overwhelming evidence.
Right. So, in order to be committed for just 6 months after an admitted killing, the judge has to find he's crazy beyond a reasonable doubt. But we can acquit him if there's any doubt that he's crazy. Does that make sense?
See,
or is that crazy?
It's so funny because, look, this whole thing is crazy, and he's clearly crazy, but not legally. Mm-hmm. Not legally,
So you agree with the prosecution?
Yeah, look, I want to agree with the prosecution, but look, I do. I think they've got a great case here. But the defense, to their credit, is playing their hand masterfully.
Now, in the jury instructions, there's an admission here that there's no real definition for mental disease or defect under the law. So they kind of grab something out of nowhere, and it's very broad. It says you can have a mood or a thought disorder or an emotional disorder. What do you make of that lack of a definition in the law?
Well, look,
does it impact the jurors' ability to come up with a conclusion here?
Yeah, it's a little bit vague, but I think that's a good thing because the DSM, the Diagnostic Statistical Manual, it's constantly updated, periodically, and things that were mental health issues are taken out, things are revised, given different names. So it's very fluid, and I think it's good that the law defers to the mental health experts. But look, at the end of the day, you've got to not be able to tell the difference between right and wrong and not be able to conform your actions to the law.
And in this state, because it differs state to state, it's either or. You can get off if you can't know the difference between right and wrong. You can get off if you can't conform your behavior to the law. There's broad leeway there for somebody to get acquitted after they commit a gruesome crime like this.
Yeah, well, I don't think Mr. Loya is getting acquitted. As good of a job as his defense attorney is doing, I expect probably guilty on all counts.
Okay, well, the court is back in session, but let's really quickly talk about one thing. The witnesses cannot sit.
They cannot sit. Maybe we should institute that on LawNewz.
That is unbelievable to me. What is this, the 18th century?
Look,
Where's the judge's powdered wig?
Yeah, well, I might want to wear one of those.
All right, let's go back to the court now to listen to the trial.
Commonwealth rests. And with that, jurors, enjoy your lunch. Please be in your jury room ready to go at 2 o'clock. I'll bring you right down and put you to work. Thank you.
Juries, all rise, please.
The jury is out of the room. This is a public courtroom. All are welcome to attend. It's open to the public. The public's encouraged to attend. Out of respect to the hard work of the jurors, it would be most appreciated if people who are not using electronic gizmos for media functions, in other words, news gathering functions, but instead for their personal use, would not use them while the jury's in the room. It's disrespectful to the jurors to be holding your device and tinkering with it, or holding it in your lap, obviously tinkering with it. These folks are working very hard. Show them the respect they deserve. Thank you. Attorney Sagadella.
Nothing.
All right. Lunch and recess.
All rise, please.
And welcome back to the Law News Network. I'm your host, Amy Dash. I'm here with Kenneth Belkin, criminal defense attorney, and the defense has rested in the Commonwealth.
Well, prosecution.
The prosecution,
The
I'm sorry.
people.
The prosecution has rested in Commonwealth. I was distracted by your beauty.
Thank you.
So, what did you make of the prosecution's case? Did you feel that it was strong enough to prove beyond a reasonable doubt, because the burden is on them, that Adrian Loya was not insane?
I mean, I think they've got this one. I think, and look, the burden, the defense has to prove that he's insane and not criminally culpable. But I think they've got a slam dunk, and I'm not usually one to think that. I'm always I'm biased towards the defense. It's part of my job. I have to be. But this is really, the evidence is overwhelming. The staging, the planning, the deliberation, his manifesto. I'm surprised the prosecution didn't get more into his manifesto. But I think that's probably because this manifesto was probably filled to the brim with lunacy And I imagine the defense is going to probably try to introduce it to show that this guy was not in his right state of mind.
So you think that the prosecution essentially cherry-picked from the manifesto and didn't go too deep, because if they did, it would have undermined their case because it was full of
Yeah, I
crazy
think the
ramblings.
defense is probably going to go there. I mean, I haven't seen the manifesto. I don't know what it says, but I would imagine 250 pages, a manuscript leading up to what was intended to be a double homicide and a suicide, but it ended up just being a homicide. You know,
But we
it's
saw
got to
that-
be filled with
we
some
saw
very
that, though,
interesting
Ken,
tidbits.
The James Holmes case, the Colorado
Yeah.
movie theater shooting. I mean, there were ramblings in that diary where he literally wrote the same word over and over from the top of the page to the bottom, and they decided that he was not insane.
Yeah.
Why do you think there's a hesitation when looking at somebody's actual writings, which can indicate their state of mind? Why would a jury not find that persuasive?
I think it's tough. I think it's especially tough for jurors in cases where there's been a loss of human life, where someone has died at the hands of this person. They want someone to be responsible, and it's not enough to say, oh, he's crazy, let him go, let him get treatment. That's not enough. It doesn't jibe well with people. It doesn't jibe well with me, quite frankly, when someone loses their life. People have to face consequences.
So do you think then that the law should change? Because it's essentially that way across the entire country.
No. See,
Why?
let me
Okay.
qualify that. While I do think that as a juror you want someone to face consequences for taking another life, I do think there are genuine mental health issues and mental health diseases and illnesses that affect someone's ability to appreciate reality and to understand the difference between right and wrong. There are those genuine people. You know, if Mr. Loya was someone who thought that maybe this lesbian couple were Russian spies and they were spying on him, and that if he didn't kill them, they were going to detonate a nuclear bomb
You're
in New York
talking about
City.
delusions.
Yeah, if he was delusional and he could not discern between right and wrong and thought he genuinely needed to commit murder to prevent further loss of life, or had some sort of bizarre rationale where he just that was not rooted in reality, I think that's a case where that person probably should not go to jail and should get treatment.
So to play devil's advocate then, the fact that he did this based on his belief that she had sexually assaulted him, whether it was right or wrong, does that make murder excusable?
No, because look, just because you're sexually assaulted by someone, we know that we have a criminal justice system. We know there are ways of dealing with this. And he obviously knew there was a way of dealing with this. And he obviously knew that the way he chose to deal with this was wrong, it was illegal, and it would bring upon him the full brunt of law enforcement. I mean, he said in his interrogation that he intended for this to end in suicide by cop, that he was going to be shot dead by the police. He was actually amazed at the restraint they showed him.
And also, one of the psychiatrists said that the fact that he believed that he should die, the fact that he apologized, and the fact that he didn't want anybody else to die besides his alleged
It's
victim.
evidence that he knew.
It's evidence he knew.
He was
Exactly.
wrong. He was in the wrong.
And it's evidence also in his manifesto that he was weighing what to do, that he was thinking about, should he do it? When should he do it? How should he do it? Maybe he shouldn't do it. And the fact that he's weighing shows that he had the ability to control his actions but chose not to.
Yeah,
Is
and
that believable?
He waited a very long time. It was over a year between the alleged incident that he was retaliating from and this murder.
Well, he needed a lot of rehearsals in between.
Well, he likes to rehearse.
He does.
Don't we all?
Yes, and you know, he basically outfitted himself in fatigues, combat boots, he had the guns,
Yeah.
he had guns stored at the home. He had a plan to divert the police and block them from responding to the scene by basically setting his own car on fire. That shows meticulous planning according to the psychiatrist. So as a defense attorney, how do you overcome her very powerful testimony that this man knew what he was doing and had the ability to control it?
There really is no overpowering this. You just have got to drill in there that, look, the prosecution's own first psychiatric expert, Dr. Martin Kelly, had come to the conclusion that this guy was not guilty by reason of insanity, which, which probably wasn't even an admissible thing to say because it's drawing a legal conclusion on the stand and it's objectionable, but, no one objected to it because, one, it's the prosecution's witness, and two, why would the defense object to something that's so helpful to their case? I think, I would just hammer in that 15 minutes where he's talking to himself. I mean, he does sound crazy. He really sounds crazy when he was talking to himself. And the fact that Martin Kelly came on right after that and said he's not legally responsible, I think those are the two trump cards, so to speak, the defense has to play. And they're not very persuasive points.
Can you attempt the theory that somebody can be crazy in one instance and then all of a sudden do a roundabout and be totally sane, act sane, function in society? Can't you say that craziness is unpredictable?
Well, yeah, it's unpredictable, but at certain points, if you get medication, you get treatment, you can control these things. There are very powerful antipsychotics on the market that could keep people who have schizophrenia from having the symptoms.
What about the fact that she felt he didn't suffer from autism because of the activities that he did, that he had a wide range of interests, that he liked to watch shows which require his understanding of subtle humor, like Modern Day Family?
Well, look, just because he watches something doesn't mean he understands it. I watched, my mother would have PBS on when I was a kid. I really didn't understand most of it when I was 5 years old. But
it all
look,
makes sense now.
It all makes But, look, I think these are two experts. They came to different conclusions. And I think, who's to say even if either of these experts' conclusions are the correct conclusion? It's not like these are professionals who were treating him for a decade or 2 decades. They had limited contact with him. These experts aren't going to be seeing him every day for a couple of hours a day over a period of years. They'll see him when they see him, they'll look for some symptoms, and they'll draw a conclusion.
So if you're the defense in this case, what is your first step when you start your case? Who are you calling first, and what is your first attempt at undermining what the prosecution has done so far?
Well, you're going to want your own experts, for sure, and hopefully those experts will have spent more time with your client.
Do you put the medical experts on first?
I would put the medical expert on first. I would also want to think about putting him on the stand. That
is a bold move.
I know. The conventional wisdom is don't put your client on the stand. I can tell you this. I've lost 1 trial out of 7, and it was the one trial where my client didn't take the stand. You can tell a jury till the cows come home not to hold it against the defendant for not testifying, but in the final analysis, the research indicates they will always hold it against the person for not testifying. They want to hear straight from the horse's mouth what was going through their mind when they did it, and if they didn't do it, they want to hear an explanation as to why they've been accused of it. And I think this guy is the single best witness to say what was going through his mind, and if they want to establish an insanity defense, he's the one who can say, I didn't feel in control, what I was doing, I couldn't tell if it was the right thing or the wrong thing, whatever he has to say. Obviously.
The fact that he presumed that he would die, and even said that he felt it just that he should die after killing her, will that bear upon the jury's decision?
I would think so.
Will they find his life less valuable because he himself doesn't even think he should be here after committing that crime?
I mean, I think they're just going to be so shook from the GoPro footage, from the testimony of the spouse of the murdered victim.
Because she was there, she was wounded herself.
They thought she was dead at first when they responded to the scene, the police. Look, I mean, I think there's so much overwhelming evidence, and that woman, her testimony was heartbreaking. She had to leave the courtroom at certain points when they played the video. The jury's gonna convict here.
And right now, the jury is watching this horrific video because Adrian Loya strapped a GoPro to his stomach and filmed the entire ordeal of him killing this young Coast Guard who he was clearly obsessed with. We're going to toss to a quick clip right now of a medical expert that testified, Dr. Holtzin, and then we'll come back and discuss this very controversial topic of the insanity defense and how it's handled in the state of Massachusetts.
Sir, you remember you were under oath yesterday?
Yes, I do.
Remain under that oath today, please.
Okay.
Counsel, when you're ready, please.
Thank you. I believe we left off, you'd indicated that you were discussing with Mr. Loya his version of the events. And I believe you had indicated something about the mattress. Could you just start from that point? Did he tell you something about the mattress?
Yes, he did.
What did he say?
At one point, Mr. Loya communicated to me that the mattress from the bed had come up to his face, and that he had pushed it back down away from him.
And then what did he say next, if anything?
He then stated that he pulled out a gun and began firing it into the mattress.
And what was his demeanor during that portion of the interview?
He was quite emotional.
And what did he say happened next?
He said that he heard Lisa gurgling and then he left.
What did he say he did when he left?
After he left the home, he said that he was going to do battle with the law enforcement people, and he communicated to me that he went outside and waited for them. And at one point, he said he saw a silhouette. He heard some voices of people approaching, and then in the darkness, he saw a silhouette, and he said he fired at the silhouette. He didn't say how many times, I don't believe, he told me.
When he was speaking with you, did he indicate when he first went outside that there was an item outside that he did something with?
Well, he had a rifle. He said he had a rifle.
Did he mention a boombox?
Yes, he did.
Tell us about that.
He said he had a boombox and that he was playing music.
And you indicated that he saw silhouettes and he shot, is that correct?
Yes, he shot at one of the silhouettes, he said.
What did he do after that?
He said that he I think the word he used was retreated, and went to, he said he went to the porch of another home, I believe, and sat on the porch, and then he said he didn't hear anything, heard like the wind, but didn't hear any people, and then he got up from the porch, and he said he removed some article from him. I don't think it was a belt, maybe. And then he put his rifle down and walked to a place where there was a light, like a lighted area. And he said he had his arms up. And he said, "I guess I was surrendering," were the words he used to me.
Did he indicate what, if anything, happened next?
Yes. Mr. Loya said that the silhouettes approached him, and then he was told to, or he said I think he said he was kneeling at one point, and he said he was placed under arrest, and he said that the whole time that the law enforcement people were approaching him while he was there, again, it wasn't clear to me whether he was standing or kneeling at that point, but at the point where he had his arms up, he said that whole time he was hoping that he would be shot by the police. And he said he was handcuffed, and that there was a dog, a police dog, that was there as well.
And did he say that he had said something to them about the dog?
Yes, he said, not the dog, not the dog.
Did he indicate he had some conversation with the people that were approaching him? Other than the not the dog?
Yes.
What did he say he told them?
So Mr. Loya communicated to me that someone there had asked him what happened, I believe is what Mr. Loya told me, it was the question. And he responded by saying that he was raped. He said, "I was raped," like repeatedly, or "she raped me" repeatedly, one of those two phrases.
And did you ask him about what his mission was that he decided on in Virginia?
I did, yes.
What did he say about that, if anything?
Well, he said there were two components to it. One, that he was going to come to Massachusetts to kill Lisa for, as he put it, what she did to him. And I believe he said something to the effect of, "She ruined my mind," or "She ruined my life," or both of those things. And that the second part of his mission, that he was going to engage in law enforcement in a gun battle so that he would be killed, because he said he was suicidal.
Did you ask him where he was now with what he had done?
I did. I asked him about where he was with the event.
And what did he say, if anything?
Mr. Loya initially said that he continued, at that point in late late July of 2015, he said that he still hated Lisa. And then I asked him a second time where he felt he was with the event, and he said he couldn't believe that it it happened. He couldn't believe that he's still alive.
And did he indicate what his feelings were towards Lisa at that time?
Yes, he said at that point that I hate her, or something to those words.
And were you able to form a clinical opinion regarding his criminal responsibility?
Yes.
And that was based upon your interviews and the materials that you had reviewed?
Yes.
Could you tell us about the process to forming that opinion, please?
Well, the process was interviewing Mr. Loya under the Lamb warning, and also reviewing the records that were made available to me, which included a Detective Noble, I believe his name was, and including a narrative of the offenses.
And were you, I'm sorry.
And then asking, trying to determine Mr. Loya's mental state at that time, and also shortly before the time of February 5th.
And when you conducted your interview, that would have been on, formed your opinion and wrote your report. That would have been on August 5th of 2015?
Yes.
Did you have an opinion as to whether Mr. Loya was currently, at that time, suffering from a mental illness?
Yes, again, I opined, as I had earlier, that he suffers from a major depressive disorder.
And did you then opine as to whether or not he was suffering from a mental disorder at the time of the crime?
Yes.
And what was that?
It was my opinion that Mr. Loya was not suffering from a mental disorder at the time of the offenses.
And with respect to his ability, well, his criminal responsibility, tell us about what your opinions are on that and what you base that upon.
Well, first of all, Mr. Loya was someone, despite his saying that he was suicidal every day for a long period of time, I believe it was October 2013, he was someone who was not engaged in any mental health treatment in the months before February 5th, 2015. He was somebody who was gainfully employed. He was someone, in other words, he was someone who was functioning in society as a non-mentally impaired person, substantially impaired person. So it was. That was a core reason why I thought that he did not suffer from a mental illness as it's defined by statute law.
And what about your opinion concerning whether Mr. Loya was able to both appreciate and comport his behavior to the requirements of law?
Yeah. So with respect to those two components, Mr. Loya described to me that he planned out this act for quite some time and took some steps indicating that he was going to make this act happen. As I testified yesterday, he donated some items to an organization before he left Virginia. He paid his bills. He did all of those things in a rational, responsible manner, showing that to me that he was somebody who could make proper decisions.
And based on the available information, what was your opinion concerning Mr. Loya's criminal responsibility?
That he was criminally responsible for the crimes committed on February 5th.
Thank you. Yeah, that's all I have. Oh, I'm sorry, one other. Did you write a report concerning this incident?
On Mr. Loya?
Yes.
No, the last reports that I wrote for Mr. Loya would have been in July, early August, based on my late July reports.
I'd ask you to look at that, tell me what that is.
It's my criminal responsibility evaluation dated August 5th, 2015.
And that is Dr. Holtzen, who was another medical expert for the prosecution, basically again saying that he didn't believe that Adrian Loya met the legal definition of insanity because he felt that he could understand the difference between right and wrong, first off, and second, that he could conform his behavior to the law. And I'm here with Ken Belkin, criminal defense attorney. That's the test.
Yeah,
that is the
that's
legal
the
test
test
in Massachusetts, but it varies state to state. But when you're doing an analysis as a juror about whether somebody is insane or not, everything that they do leading up to the crime matters, right?
Yeah,
You're looking at
absolutely.
everything.
And their past, you know, if they had been diagnosed with a mental illness, if they had seen specialists in the past that could attest to the fact that, you know, they have an illness where they can't appreciate the difference between right and wrong. Look, this guy's failing the insanity test, all right? And it's not a test that he wants to fail given the situation he finds himself in. I mean, I think the only person in the state of Massachusetts that's willing to say that this guy is insane is Dr. Martin Kelly.
So let's start from the beginning. Apparently, what sets this all off is the fact that he's on a tour in Alaska with two colleagues, and they're married, two females, and he believes that one of them, this is what he says, invited him over for some sort of a drunken get-together, and he said that she sexually assaulted him, but then he goes on to say that she never touched his genitals or invaded them.
He felt like he was mentally raped. I
mentally
think
raped,
that was
okay. Doesn't that come off as somebody who's not quite right in their mind?
Yeah, I mean, I feel like I have probably five phone calls a day that are mentally raping of me. But, you
Probably
know,
during my interrogation of you right now, you're feeling mentally raped.
maybe your text messages from earlier.
Yes.
But look, you know, even if everything he said that happened with this woman happened, that's not an excuse. Sorry, you don't get to go and try and murder this gay couple.
But does his perception of what happened make it excusable because it indicates that maybe he is insane?
Look, even if this didn't happen or it did happen, it doesn't matter. My hunch is probably something weird did happen. He probably went over there and they had a little too much to drink, and maybe someone got a little frisky with the other person and it wasn't reciprocated.
But from that point on then, Ken, he becomes obsessed, and to the point where he's blaming her for his dog even getting sick.
Well, he lost his job as a result of this. You know, that was the thing that really killed it for him. And look, a man loses his job, things can go a little sideways for him, but still does not make an excuse for you to commit or try to commit a double homicide.
Okay, so according to the psychiatrist, he's then overwhelmed with hatred towards this woman, starts blaming her for everything, becomes totally obsessed, and that's when he starts planning out her murder. So let's go through it and let's examine whether he's insane or not. So he goes and he gets all of the equipment. He's got guns. He's even honing his shooting skills in the months leading up. He's planning it out to the extent that he is doing reconnaissance missions where he is doing rehearsal dry runs of how it's going to go down. He buys all of the fatigues. He's tactically dressed. He goes and stashes some guns at a neighbor's house. He comes up with a plot to set his car on fire. And then he writes this 200-plus page manifesto, basically leaving it behind as evidence of everything that he did and why. So all of those preparatory steps, what does that bear upon when you're doing the insanity analysis?
Well, I don't necessarily think it plays into the analysis. Someone can go and take all these deliberate steps and this complex preparation and still be insane. You know, in a scenario where he harbored a serious delusion that he had to kill this person for maybe the good of the country or something much worse would happen, if, like maybe some sort of superhero spy movie playing in his head, you know, he could still do these complex steps and he would not appreciate the difference between right and wrong.
Even if he's delusional. So you're saying that the planning really can be tossed out the window by the jury.
Yeah,
It's
I think
not
the planning
relevant.
can be, it's relevant so insofar as it goes to prove deliberation and premeditation to prove the first-degree murder charge. There it's relevant. As far as the insanity, no. People do all sorts of, they take all sorts of preparations to do things.
But the
whether
fact
they
that
be
somebody
insane or
can
not.
function and prepare in this way, the fact that somebody can think about setting their car on fire because for the reason of blocking the police from responding, isn't that a logical thought process?
Yes, that is a logical thought process. But who's to say that someone wouldn't undertake that same method of preparation for an illogical thought process? You know, just because he had deliberate reasons for doing these things, and, you know, they might be bizarre, but he certainly knew the difference between right and wrong.
Okay, so then he commits this horrible crime, and the way he commits it, does that bear upon insanity? The fact that he straps a camera to him, he films the entire thing, he's got a soundtrack for the murder that goes from heavy metal rock while he's pumping bullets into this young Coast Guard. And then all of a sudden, there's a symphony playing, as if it's like Nazi Germany or something, and there's a dead body on the floor. Does that at all indicate whether he was crazy or not?
Well, Wagner does go well with mass homicide, but, you know, he just, I think he made a playlist. Doesn't necessarily mean he's crazy. We got to remember, if people were considered legally insane for doing crazy things, half the people to 75% of the people incarcerated right now and convicted of crimes, they would be in mental institutions, not prisons. The fact of the matter is...
No, but maybe that is true. Maybe a lot of people that have committed crimes that are in prison should be in mental institutions, but
I'm
our
sure
law
a
is
lot
not
should.
structured that way. I mean, if you're going to say, if you have a reasonable doubt over whether somebody's insane, you have to acquit them, then I would think everybody gets acquitted, because somebody who kills someone, you got to think that they're crazy.
And naturally,
in some way.
naturally they are crazy. But are they crazy in the sense that because of a mental health disease or defect, they can't appreciate the difference between right and wrong and conform their actions to the law? Or are they just doing something crazy?
Well,
Yeah,
that
plenty of
definition
people
is
do
200
things-
years old, though, very much like this court
But
system
it's
where
there.
we're seeing, where they have the witnesses standing, the judge gets to sit, the witnesses have to stand. You've got archaic rules of procedure from the 18th century. Everything's there except for the powdered wigs. That's
But look,
insane.
we need this standard
But
of
but
insanity.
that court reflects the definition of insanity, because it is that old. It is 200 plus years old, and it has not been updated.
You're
in
not
many
into
states.
this standing thing.
I'm not, and you know why? Because the only times when the definition of insanity has been updated, in states like Colorado, for example, is to broaden it and give even more leeway to somebody being crazy. For example, in Colorado, even if you know the difference between right and wrong, if you couldn't control your impulse to kill, then you can get off. That's backwards thinking. If somebody can't control their impulse to kill, why should we put them out on the street?
Well, look, they're not going to get put out on the street, and be free. They're going to be committed. But if someone
For maybe a month or two.
But look, if someone genuinely can't control their impulses, are they criminally culpable? Intent is an element of these crimes. And if you didn't intend to hurt someone, you can't prove it.
And so here, how would you compare this second prong in Massachusetts, where if you can't conform your behavior to the law, that's even broader than if you can't control your impulses?
Yeah, I mean, look, I think this guy could conform his behavior, because he did conform his behavior for a very long period of time between this alleged incident that he was retaliating for and the date of the murder. He did conform, and he conformed his actions to prepare for this incident.
What about the fact that he's got a prostitute with him the night before, and he blames that on Lisa too, the victim, saying that he had to test out whether he could still perform after the sexual assault?
I mean, this
Is that
guy,
relevant at all?
This guy has got some serious sexual issues. I think that's clear. I think the whole thing he's retaliating from, something happened that night. No one knows what happened that night except for the victim and the defendant. They're the only two people that know what happened on that night. But you can throw that all out, because it doesn't matter what happened on that night. Whatever happened doesn't give him the right to, a year and a half later, plan a double homicide that results in one woman being murdered.
After he commits the murders, he's extremely calm. Even though he hasn't been killed, he expected that he would die. But he's totally, euphoric. Does that play upon his level of insanity or not?
He indicated to the police that he knew what he was doing was wrong, that he expected the police to kill him because he deserved to die for what he did.
So the first prong is satisfied.
It just shows through that interrogation footage, shows very clearly, and that interrogation was taken shortly after the incident. It just shows he knew what he did was wrong, and the only error made here on his part in his plan was that he wasn't murdered by the police.
So do you think this is totally open and shut?
I think it's pretty open and shut, but it's going to be very interesting to see the experts that the defense puts on and to see if they're persuasive to the jury.
But isn't it going to be much more of the same? Asperger's, autism?
Yeah, it's going to be Asperger's,
himself?
autism. First of all, I find it incredibly insulting that they're insinuating that people who suffer from Asperger's and autism, even high-functioning people who suffer from it, like Mr. Loya, can't appreciate the difference between right and wrong and see that it is wrong to take another human life.
Right, so basically what they're saying is that anybody who's diagnosed as autistic or Asperger's syndrome could go out and kill someone and they shouldn't be held criminally liable.
What next? ADHD?
Right, so you're justifying it based on not insanity, but an entirely different mental disease or defect.
And by the way...
And is that even diagnosed as a mental disease or defect, autism and Asperger's?
Well, it's certainly a mental disease or defect. But, also, let's not forget that we had Dr. Martin Kelly, who said he suffers from this, Asperger's, or he's on the autism spectrum. Then we also had the expert that testified after him that said, no, he does not suffer from this. So it's not even clear if he even has Asperger's or autism. My feeling is probably that the defense needed to put forward an insanity defense, and they were grasping at straws for mental illnesses that he might suffer from. And the one that his symptoms might have come closest to was Asperger's and autism.
Well, if you take Dr. Judith Edersheim's testimony and you place a lot of heavy weight on it, basically she belies the entire theory by the defense of autism or Asperger's, and she goes into specific details where she says that people who have these types of problems have peculiar gestures. They have language and speech behaviors that don't sync up. They don't understand people's facial expressions. They misinterpret them. They don't understand social cues, and they're solitary, a lot of them too. When they need support or help and they're emotionally upset, they're not going to reach out to somebody. And then she goes into all of his behaviors that contradict all of those.
He doesn't get
signs.
Sarcasm, which means he probably couldn't be friends with you.
He does get sarcasm.
Oh well, he does.
Yeah,
so
but
then
I'm not
maybe
looking for another friend like that.
Fair enough. Look, it's first of all, it's not clear that someone who suffers from autism or Asperger's can't appreciate the difference between right and wrong. That's not clear. It's not even clear
spectrum.
that he has it. He was, never diagnosed with it prior to this during his formal education. During his time in the military, in the Coast Guard, there's no record that this guy suffered from anything.
And one would think there's a very vigorous screening process.
Yeah, there's at least a very basic psych eval before they allow you into the armed forces.
She also said that when he was in the Coast Guard, he was able to conform his behavior to their very strict protocols.
Which is much more strict than civil society. You're in a military setting.
Right. He hasn't been able to shake it because he's standing at attention to the judge, which is a little bit bizarre. It's peculiar behavior.
This guy is, look, not normal, definitely crazy, not legally insane, and therefore should not avoid the consequences of his actions.
All right, so we are going to throw